To this evidence session for the Home Affairs Select Committee into future security cooperation with the EU on the 1st of January. Very grateful to have with us the Right Honourable James Brokenshire, the Minister for Security at the Home Office, Paul Lincoln, the Director General of the Border Force, and Chris Jones, the Director for Europe at the Home Office. Can I begin by just asking you about the current emergency situation as a result of the border closures? Could you tell us what the latest is and what the implications are for Border Force?
Chair, thank you very much, and thank you for the opportunity to give evidence this afternoon. As you will have heard from the Transport Secretary, we are working closely with Kent Resilience Forum, Kent County Council and Highways England on various contingency measures. Operation Stack on the M20 has been activated to queue lorries travelling towards the continent to avoid causing gridlock across Kent's roads. And the site at Manston Airfield is being readied should it be needed to hold traffic for the port of Dover. The Kent Resilience Forum will deploy their driver welfare plan should this be required if the queues build significantly on the M20. And the Kent Resilience Forum will move quickly to deploy water, medicine, warmth and sanitation. As you'll be aware, Chair, the Prime Minister is going to be chairing a COBRA this afternoon to discuss the situation. We obviously note that the French Transport Minister has said they're going to establish a solid health protocol in the next few hours to ensure that movement from the UK can resume. And obviously, we are working very closely with the French authorities to get this resolved. Unaccompanied freight is obviously still continuing, but Paul Lincoln from Border Force may also be able to offer a direct operational insight on current work with Border Force and how we are managing some of those immediate pressures for our operations as well.
Yes, please, Mr. Lincoln.
Yes, thank you, Chair. I mean, just to build on what the Minister has just said, effectively, though, Border Force operations continue without any disruption to what we have done before. The French have continued to allow us to deploy to the juxtaposed controls. This was a situation which we had anticipated that there may be some disruption at some point during the course of proceedings, and we have had contingency plans in place for some time. We are alive, of course, to the risk that there may be queuing lorries in France and that might have a displacement effect for illegal migration. And as part of our wider contingency plans, we'd already upped the number of dog teams and the like which we have there. And I've had reassurance from the French this morning that they are also alive to this risk and that they continue to deploy, as you'd expect, police aux frontières to tackle the illegal migration risk as part of that. I should just also say, if people are concerned about vaccine importation, that is continuing as planned. I won't say where or at what time, but we have today processed vaccines into this country as planned before, so that continues.
And there's some reports of the protocol, Minister, that you referred to, including requirements for testing of drivers. Do you have locations where you could operate the lateral flow tests or PCR tests or other kinds of arrangements that you might need for people who don't currently have a negative PCR certificate?
I think that these are matters clearly of detail for Kent Resilience Forum and for DFT, which no doubt will be discussed at the COBRA session later this afternoon. So unfortunately, I can't offer you further details as yet. Indeed, those are likely to be, if needed, operated by other government departments. But obviously, this is a moving situation. We are and will remain in close contact with the French government and authorities as they set out any further requirements, indeed discussions that we will have in order to get the flow of freight moving. And I think there's a recognition of a shared interest, a shared need to resolve this. Obviously, some of the operational aspects will no doubt become apparent later, but as Paul Lincoln has indicated, we are used to having queues from time to time at the border because of various different issues, whether it be weather-related, whether it be strike-related, that obviously impact on the short straits. And therefore, the well-rehearsed plans that Paul Lincoln indicated in terms of how we deal with this. But clearly, discussions are continuing with the French government, and the Prime Minister, I'm sure, will have more to say on this later today.
So does this mean that if testing is required, you don't envisage Border Force playing any role either in the operation of that or in the assessment of compliance? Obviously, Border Force's role normally, whether it's on behalf of customs or on itself, is the compliance check. Does this mean you're not expecting Border Force to play any role in any compliance check?
I think it's too early to speculate. And as I say, we are still waiting to hear from the French government as to the detail of any specific requirements and indeed how that would be operationalised if required. I think that the focus clearly is on ensuring that we can get flow of freight moving as quickly as possible. Obviously, positive to have the discussions with the French authorities that are taking place as we speak. Obviously, as you'll have heard from Paul Lincoln from Border Force, we're obviously very conscious as to what this means for our workforce and well-being of our staff and support for them. And clearly that will be factored into any arrangements that might be needed.
And Mr. Lincoln, you referred to contingency planning having been done. So were contingency plans in place exactly for an event like this, a closure of the border for some other reason in the run-up to 1st of January?
Thank you, Chair. I mean, I wouldn't put it quite in those terms. What I would say is that the government published earlier this year a reasonable worst case scenario for potential disruption at the border, and we have planned against that scenario. So this is well within the constraints which we would have expected to have to operate. And of course, as the Minister said, you know, there have been numerous occasions over the past few years where there have been, unfortunately, blockages for a variety of different reasons. So our plans here are well rehearsed.
So my understanding of the reasonable worst case scenario is that it doesn't include the kind of high impact, low likelihood events like this, the complete border closure just 10 days in advance of new arrangements coming into place. So perhaps you can confirm maybe it does. Is your assessment then that the impact of this doesn't take us beyond the reasonable worst case scenario that the government had assessed, or is this beyond that reasonable worst case scenario? Because it kind of looks like it is.
I mean, I think we'll go back to what the government published previously, which was up to 7,000 lorries for up to 2 to 3 days for a period of up to 3 months. So, you know, we are capable of collectively in government dealing with that scenario. What we have done in the last sort of 24, 48 hours is respond to the situation as we've seen it. And the position that the French have put so far is that this is for a period of 48 hours. It's to be under review. And as the Minister said, they are looking for a position to try and resolve on freight.
So your assessment is this doesn't add to the 7,000 assessment, and this doesn't in any way increase the worst case scenario compared to that projection?
No, I mean, if you look at this in just general terms, I mean, when you're looking about the volume of traffic which comes across the short straits on any given day in a closed loop system, it isn't actually physically possible to get to a certain level. So it's not an additional level. This is just a base level which we're talking about.
Sorry, just explain that.
So if there are, you know, 10,000 roughly lorries going each way, then you can't get above a certain threshold in any case. So what we're talking about here is a situation where we have seen freight, which is currently stacking outside Kent. Actually, the incoming situation at the moment is relatively reasonable. So we're not seeing big queues, or certainly we weren't an hour or so ago, in France trying to come in. So it's not as if we're trying to see 2 lots of queues both ways at the moment.
In terms of how long you've got before this needs to be resolved so that it doesn't have a major impact on your 1st of January operations, when do you need the border reopened again?
So this isn't an issue for Border Force to be able to conduct its operations. We have staffed and trained and had these contingency plans for some time and operate them regularly. This is more a question of, Department for Transport and other parts of government dealing with French authorities as to when we can resolve the situation that we see in front of us. But it's not a border force related issue in that regard.
Obviously, Chair, the indication from the French authorities is that this is for 48 hours, and obviously discussions are continuing at pace, given, I think, the mutual desire to see that this is resolved as quickly as possible.
And Minister, obviously, in terms of the broader implications, even if Border Force is able to operate its bit well, in terms of the wider impact on supply, on whether it's going beyond medicines, on food supplies, on other wider operations, are you confident that if the borders are reopened again within 2 days, it will have no additional impact on your 1st of January operations?
I think the point to make on this is that for example, things like the food chain is very resilient. It has shown itself to be so over the last number of months. And indeed, the points that Border Force have underlined in terms of being able to ensure that the vaccine, for example, is able to continue to get into the UK. Clearly, we have seen increases in flows as compared to say this time last year in terms of people being prepared for the end of the transition period and therefore further movements that have taken place. But at this stage, I don't think that we see any material change to our planning or our preparations in terms of the end of the year. But obviously, I would stress that there is a clear desire to see that this is resolved as quickly as possible. That is what all parts of government are actively working on. And obviously, this will be assessed at COBRA later, and the Prime Minister will give an update, or there will be an update, I'm quite sure, thereafter from the relevant minister.
And just in terms of those border preparations for the 1st of January, Border Force will be operating the 7 inland transit sites and carrying out compliance activity. Is the Border Force now on site in all of those 7 sites?
So we are on site on some, but the planned handover dates with HMRC and DFT are over the next couple of days, and we're confident that those will be handed over to us for our familiarisation so that we're operational by the 1st of January.
So how many of the 7 are you not yet on site for?
So we're not sort of occupying on 5 of those 7 sites as we speak, but we do familiarisation, and our teams are confident that we will be able to put in place the procedures that we need to do for the 1st of January.
Blimey, it's only in 10 days' time.
But the processes that we need to do familiarisation and safe systems of work are well tried and tested. We've done this as we've taken over other sites in the past. We've been working very closely with the unions on this and our health and safety specialists, and we have dress rehearsals booked in with all the different participants as part of that process.
So you'll be on site in all of them within 10 days? Sorry, within 2 days?
We'll be on site all of them in the next couple of days.
And does that give you time to conduct or to get all of the COVID preparations and so on in place as well there?
So that is part of the process which we do. Sorry, I should just be clear. There's one site, which is Sevington, which is not scheduled to come on the 1st of January in any case. That's due to come on in February. But the other sites we will be on. And the process which we have put in place allows us, within that period of time, to take over the relevant parts of the sites which we will be responsible for, and to put in our COVID safe systems of work. We've had a lot of experience during the course of the pandemic on this, and of course, Border Force, unlike a number of other organisations, were at ports and airports throughout the whole of that period.
And in terms of the training and support for those staff, I understand you're only aiming to have trained 80% of staff before the 1st of January. Who are the remaining 20% who don't need the training?
That seems to be a misunderstanding. As of Friday night, we were on 97% completion of training.
That's very welcome. That's and then in terms of having sufficient staff, do you have all of the staff that you had aimed to recruit?
Yes, we will have the numbers of people which we expected to have in place by the end of the year. And on top of that, we have got a couple of hundred additional contingency staff to make sure that we are as robust as possible for that period.
And in terms of any implementation of either an agreement or not having an agreement, does that make any difference to you in terms of the border force operations in those transit sites and at the border?
No, I mean, the key thing here is that, of course, the government published earlier in the year the border operating model, which set out what would be required, irrespective of whether there was a further agreement or no further agreement. And we've therefore been operating on a sort of deal-agnostic basis throughout. And our 97% training, as we're currently talking about, with the rest to happen over the next couple of days, exactly responds to that.
And the ICU has raised concern that the border force will effectively be able to operate current arrangements, and they'll be able to operate what are effectively versions of no deal arrangements, but what they won't be able to cope with is something which is new and very different that might come out of any deal or agreement with the EU. Is that your assessment?
So I go back to what I said a moment ago, Chair, is that, you know, as published in the border operating model, the processes are the same irrespective of whether we're in a deal or a no further agreement.
Thank you. Can I turn then to the wider arrangements in terms of the security provisions and plans as well? Given what the European Parliament seems to be saying about it now being too late for them to scrutinise and agree to any deal, is it your working assumption now that there won't be a security arrangement in place on the 1st of January and that you may be facing at minimum an interim period without those security cooperation measures in place?
Obviously, we remain at a very delicate part of the negotiations, and as the Prime Minister has indicated, the need to go for the extra mile, perhaps we're going for the extra kilometre as we speak. But I think it is still possible to have an agreement into place, but obviously that requires an overall agreement. And as the Prime Minister and others have underlined, there still remain gaps, and the EU still needs to move to have that into position. But negotiations are continuing. The most likely outcome, based on where we sit at the moment, is no further agreement, and therefore being prepared on that basis. And that absolutely is what we have been doing.
And let's suppose an agreement were to be reached tomorrow, just in terms of implementation timescales now. So we're now only 10 days to go. Do you need are you likely to need additional legislation or other parliamentary measures and so on, just on the security side, that you would need in place by the 1st of January, which would mean that whatever happens, we're now facing an interim gap?
Well, clearly, if there is agreement, and that's what we continue, and our negotiators in Brussels are continuing to advance, depending on the nature of that, that may require legislation. And as the Chancellor of the Duchy of Lancaster indicated last week, that we stand ready for Parliament to be recalled should further legislation be needed. And therefore, it is those contingencies that we are preparing for in terms of ensuring that we can be ready and in place for the end of the year, with seeking to give as much parliamentary scrutiny as is possible, depending on when an agreement is concluded. But as I say, at this stage, we remain in a very difficult place, and our working assumption remains that there is unlikely to be further agreement.
So basically, it's fair to assume now that you've said you think an agreement is unlikely. Even if it is achieved tomorrow or in the next few days, we're likely to be facing a security gap in January where we won't have those cooperation.
No, I wouldn't. If an agreement were to be reached, I think that, as we have indicated, we would be able to recall Parliament to be able to deal with any necessary legislation. And I think it is obviously the EU will be considering these issues carefully on their side too. So no, I would not make that conclusion, but obviously we need to be prepared for all eventualities. That is obviously what we are doing in terms of readiness, and I'm sure, as we'll come on to in the session, how we will respond in relation to each of the different measures that are available.
So we want to come on to the detail of the individual measures, but just to find one just in terms of the timescale and how long you need, just in terms of implementing things or preparing things, as for example, on arrest warrant or extradition legislation and or other things. Should we expect that legislation will be needed on the security side of things in order to implement any of these things by the 1st of January, even if a deal is reached?
Well, on extradition, as you will know, we have already put some legislation into place to, for example, provide for a power of arrest, and no doubt we will come on to that in this situation in relation to the EU member states. But in relation to broader legislation, it is, if an agreement were to be reached, it will depend on the precise nature of that, and I hope you will understand that I'm not really in a position to give detail given the sensitive nature of the negotiations. But nonetheless, should legislation be required and we're able to conclude, I believe that the steps can be taken to put things in place and to enable that to happen. But as I say, that our working assumption is that no further agreement is able to be concluded, but nonetheless that we stand ready to respond in all circumstances.
Thank you. We want to pursue some of the detail of the security measures now. Tim Lawton.
Thank you, Chair. Good afternoon, Minister. You're going to have a busy Christmas by the looks of it. Can I turn to Europol and some of the likely arrangements in the event primarily of a no-deal outcome over the next 10 days. We had a session with police chiefs and Steve Rodhouse from the NCA last week. And really out of that, how confident are you that in the event of a no deal arrangement involving security, that the UK will be able to retain liaison officers at Europol to keep up that relationship in some reduced form post the 1st of January?
Well, obviously, we seek an agreement to provide effective cooperation between the UK and Europol to facilitate multilateral cooperation. I think that it's recognised that is in everyone's interest to do so. In any scenario, we look to continue that close cooperation and have plans to transition our operational cooperation with EU member states to bilateral and other non-EU alternative channels if necessary. But obviously, we look to maintaining an arrangement, obviously not as an EU member state, and obviously it is a different arrangement that we are looking to under any scenario. But I think that we remain positive that we will be able to maintain close cooperation with Europol. But in a non-negotiated outcome, if needs be, we do have arrangements in place to ensure that UK law enforcement can maintain, to as great an extent as possible, operational relationships.
What are the grounds for being optimistic about continued relationship with Europol?
I think it's the fact that the sort of shared interest that we all have and the close cooperation that law enforcement partners have had. I should underline, for example, in relation to joint investigation teams, that we are participating currently in around 36 of those in total, some of which will carry on next year without any difference in that cooperation. And I think it is that sense of a shared desire and a shared interest to work together on that law enforcement collaborative basis. And how in terms of the negotiations, there is a good degree of convergence in what the UK and the EU have been seeking to negotiate. But obviously, we remain ready to transition to alternative arrangements. The National Crime Agency is looking to provide additional international liaison officer deployments to EU member states as well to increase UK capacity to operate bilaterally. And so it is a number of steps that we are taking to ensure that we can maintain a close collaborative approach to our working with other EU law enforcement agencies member states.
I think we all understand that. And we understand that, of course, there is great mutual interest in the UK and Europol continuing to work as closely as possible, and that view is shared by other police forces across the EU. And we heard from Rob Wainwright just after he'd stood down as the head of Europol, having done a fantastic job.
Yes, Rob did a great job.
Of saying that actually this was a political decision. There's no reason why we could not continue sharing operational data and working closely with Europol outside of the EU as we had beforehand. But these were political decisions, and I think we understand that. I was somewhat surprised, therefore, when last week, speaking to Steve Rodhouse and others in front of the committee, when I would have thought that we would have been doing more modelling with the likes of the Danish security and police forces, who, of course, not a member of Europol, but are a member of the European Union, as a sort of model for how we might find an example going forward of how we can continue to have that close relationship without actually being members of Europol, as Denmark has managed to do. Apparently, we haven't had those discussions. Why not?
Well, what I would say is that it's not that we would seek membership of the agency. In essence, it's an association arrangement, as third countries would do with Europol, and of which there are a number of examples. That is the arrangement that we are seeking through the negotiations with our European partners. And so what I would say, Mr. Lawton, is that there are clearly different ways in which you are able to work with and through Europol. That has been very much part of the discussions and the negotiations we've been having. And so, I think that's why I sort of underline that convergence in interest as to what the UK and the EU have been seeking to negotiate and seeking to achieve. Obviously, should that not be possible, it is some of these reserve arrangements, some bilateral channels, indeed how we would maintain our UK liaison from the British Embassy should that be needed. But it is, I think, that sense of how you can achieve this with Denmark or with other countries in terms of that relationship as a third country. And that is what has been informing our discussions to date.
Okay, but I think the point I was making is that Denmark have a very good relationship with Europol. They're not members of Europol, but they are members of the EU. We need to have a very good relationship with Europol without being members of Europol and without being members of the EU. And Denmark appears to be the closest to it. I would have thought we might have a lot more in common, which we would explore, and apparently we haven't. But I think, would you agree again, one of the biggest differentials that was flagged up is not that we were not necessarily eventually be able to access some of the intelligence that other police forces have, and it may be more through bilateral arrangements rather than the central database of Europol. The biggest impact is probably going to be the timing, that it is a more cumbersome process and will take longer to access that degree of intelligence. Do you agree that's really the assessment that Steve Rodhouse and the NCA have made as to the major differences? Not that we can't necessarily get cooperation, but it's going to take much longer potentially to get access to information about things that we don't know as well, that things that won't be automatically flagged up as part of cross-border investigations.
I think the point, Mr. Lawson, is that there are very clear bilateral ways of being able to share information in fast time. That is bilateral. There are also other means, for example, in relation to Counter-Terrorism, the Counter-Terrorism group of European countries, which provides that means for people to be able to share information in a speedy way. And so I think there are obviously differences which no doubt we will come to in terms of the different overall types of systems. And this is looking beyond Europol. Some of the systems obviously at the moment are automatic. There may be other processes that may need to be taken in relation to the other measures that we would need to operate that we have in place. But the point being is that those are operated with other countries outside of the European Union, and therefore the ability to make those work, they are tried and tested in that sense, and we would use those to ensure that there is a good means of sharing information, intelligence, data, and therefore to see that we are absolutely having that focus on protecting our citizens and how this country will remain one of the safest in the world.
Okay, I understand all that, Minister, but I think you have to admit that accessing information through Interpol and other bodies outside of Europol can take longer, and there's not the automatic obligation to provide that information as there is in many cases, hence a potential time delay. But you keep coming back to, and I entirely understand this, the bilateral relationships we will be having with those other Europol police forces. And the NCA told us, and you've just hinted at this, that the UK is looking to surge additional liaison officers to European capitals in the event of no deal. What additional resources are you giving to the NCA? When is that going to happen? What does it actually look like, given that you can't then put a load of officers on a train, well, you can't do that at all at the moment, but on the 1st of January, and expect them to arrive in Lisbon, Paris, Brussels, wherever it may be, to work with those other 27 police forces? What format is it actually going to take, and how quickly is that going to happen?
Well, the NCA intends to surge additional liaison officers across 11 priority EU member states to increase our capacity to operate bilaterally. Obviously, there already is bilateral connection that does take place, which the NCA takes the lead on. And so it's rather how we further strengthen that, adds to the capacity that is there. But I would sort of, as I say, point back to other forms of connection on counter-terrorism that equally allow means of sharing of data. And so there are, I suppose, a number of different methods as well as the bilateral. Indeed, how we look to the different conventions that you've referenced. Yes, they're in, it's not sort of, you can say that they are exactly the same as the EU arrangements. Clearly they are not, but they provide us with a clear and strong basis in terms of being able to maintain a collaborative approach and ensuring that we can protect our citizens.
Okay, so how are they different? Because I don't think anybody would say that what's going to happen post-Europol is as smooth and slick, as integrated as the access to the databases and the exchange of information that we have been able to enjoy under Europol. Or are you seriously suggesting that it will be just as good, if not better?
It's sort of worth just clarifying that obviously it's not Europol itself, and any member state or any country outside of being a member state does not have access to Europol's databases. But what I'm saying is that yes, there are different measures that are available, whether it be in terms of some of the things we've already touched on extradition, on providing alerts, the use of Interpol, the reliance on the Council of Europe conventions that provide the mechanisms that allow us to be able to operate. Yes, of course, they're different. And we've never suggested that there wouldn't be a mutual loss of capability, which is what we've said consistently. But nonetheless, there are clear measures to be able to see that this country remains a safe place and that we're able to arrest criminals to ensure that we provide that safety to our citizens. I think that is the point that's made, is that there isn't obviously complete equivalence between the different measures. There are different steps that we are taking, would take, if we have no further agreement with the EU. And it's precisely those preparations that we have had underway for quite some considerable time.
But final point, you would acknowledge that those alternative processes will most probably take longer. They won't necessarily be not as complete, or that we won't be able to access the information, but inevitably it's going to take longer.
I know that people have speculated on, for example, it will take X amount longer, it will take Y amount longer. I don't think that we can make that assessment, because some of that is on an average basis, on the basis of our relationships more globally. And so I don't think you can make an assessment like that. Clearly, they're different. Clearly, there will be manual processes that will be involved in some, and therefore the automaticity of certain EU measures, yes, will be different. But does that prevent us from ensuring that we protect the public? Does it mean that somehow the country is fundamentally less safe? No. And if you look at some of the measures like SIS2,
I think we get
2015.
I think we get the point, Minister, but Steve Rothaus was clearly saying the major difference will be not one necessarily of capacity, but it will be one of time to turn around that information. But perhaps that's a conversation you need to have with the NCA. That's me done, Chair.
Thank you. Can you just then confirm the answer I think you just gave to Mr. Lawton? You do accept that there is a loss of capability?
There's a mutual, we've said that there would be a mutual loss of capability. It's something that I said to the Lords Committee several months ago.
So this is a loss of capability
for the UK
and the EU.
Sorry, Chair.
Sorry, I interject. This is a loss of capability for the UK and for the EU on security.
There is a mutual loss of capability in terms of the different systems that we operate, and that is something that the government has said consistently in terms of the assessments that we have made. But actually, when we look at the overall mitigations, the different measures that we are putting in place, we remain absolutely clear that the UK remains a world leader in security, counter-terrorism, and indeed the steps to ensure that we remain a very safe place, one of the safest places.
Indeed. But just in terms of the Europol, then when the NCA says the potential loss of access to Europol without a deal is the tool area we are most concerned about from a serious organised crime perspective, and when they say the multilateral coordination and specialist analytical services offered by Europol cannot be replicated through bilateral channels, are you saying they're wrong?
Yeah, the NCA clearly will have given their assessment on the utility of Europol, and we want to see a means where we can conclude an associated agreement with Europol. That is been part of the discussions that we've been having, and why I remain positive on the basis that I think that there is a sort of a coalescence, if I can put it like that, of interest between the EU and the UK, given actually the really important role the UK plays in providing security to other EU member states as well.
We all think that, and we're all very keen for there to be a security agreement in place. Stuart MacDonald.
Thank you, Chair, and season's greetings to our witnesses. First of all, a very quick question in relation to the delays at the border with France. Obviously, the 48-hour timescale that was been spoken about earlier is pretty bad news for everyone trying to export, but for some in particular, that would essentially bring us close to a time frame where their goods are going to be pretty much written off, so food and drink, seafood in particular. So I was just wondering, is there a way, once things get back up and running, and hopefully that's sooner rather than later, to prioritise those exporters so that they're at the front of the queue, given that their goods will be written off rather than delayed for 48 hours?
Mr. MacDonald and Paul Lincoln from Border Force may wish to supplement, but part of the preparations that we've been having for the end of transition is how you're able to have category 1 goods. In other words, those where exporters of the kind that you have highlighted can be prioritised. And we're obviously very conscious of issues in relation to, for example, the export of things like shellfish, which will be, I know, very pertinent in Scotland, and how measures have been rehearsed and have been tested in terms of being able to identify and see that those exports can continue. And so it is part of the preparation and indeed the sensitivity and the timeliness which we are very conscious of in terms of the preparations that have been put in place for the end of transition. Should that be needed. But I don't know, Paul Lincoln, you may wish to think further.
I mean, the other thing I would just add, Minister, at the moment, of course, we know that there are a range of companies who are, of course, through commercial processes, looking to try and reroute to the degree which they are able to do, which of course is available to people, even if it is a bit more lengthy, and of course in some cases that will also be a bit more costly. But we do know that that is available, and we do know that conversations are ongoing on that basis.
Okay, thank you, and hopefully the processes for Category 1 goods work. Can I turn to the European arrest warrant then? So before this was in place, I think the figures are that we would extradite somewhere in the region of 60 people per year, and under the European arrest warrant it's about 1,400 or 1,500 a year. So what is it that the government is trying to achieve? Previously there was talk of something similar to the Norway or Iceland deal. Is that still roughly the ballpark? And if there is a deal, do we anticipate something like that emerging?
Thank you, Mr. McDonald. It is this type of arrangement that we did set out in our negotiating mandate, that in essence a surrender agreement that would allow for that. Obviously that takes into a case the ability, for example, for a judge in the UK to dismiss a warrant from an EU member state on the basis of proportionality, if the person faces long periods of pre-trial detention, and also if that would mean that extradition was not compliant with a person's human rights. And so it is this fast-track extradition arrangement based on the arrangements with Norway and Iceland that we are seeking, and obviously negotiations are at a very sensitive space. But it is that approach that we have been adopting.
Okay, and what would be the disadvantages of a sort of Norway-style model? What are the things that you have to prepare for in terms of contingencies if that's what emerges?
Well, if we're in a non-negotiated situation, then obviously we would fall back on the 1957 Convention on Extradition. In addition, the Extradition Provisional Arrest Act, which received royal assent on the 22nd of October, once commenced, will enable law enforcement officers to arrest individuals wanted by a specified country for a serious offence. And obviously that then takes you into Interpol red notices, and therefore the ability to identify people in that regard, and being able to arrest such that we're able to bring people into custody quickly and to manage the process. So that would be the fallback arrangement should no further agreement be reached.
But if there is an agreement, the Norway agreement is not the same as the European arrest warrant. So I'm just trying to push on what the downsides are. Am I right in thinking that one of them is that, similar to the 1957 extradition convention, it would mean that certain countries would refuse to extradite their own citizens to the UK?
Well, obviously, since the start of the transition period, there have been some countries that have not been prepared to see the removal of own nationals, albeit that what I would say on that is that that is often, and that will be the case, because it's not that people would have impunity, but because there are provisions in their national law allowing them to try their own citizens home for crimes committed abroad, and therefore it's a slightly different arrangement. But nonetheless, if I actually look at the numbers that may be of interest to the committee for the that have adopted that approach since the start of the transition period, actually looking back over an extended period, they are very, very small in number. So, for example, if I look at extraditions by nationality, between 2009 and 2019, Austria surrendered to the UK 2, of which own nationality 1. Germany surrendered to the UK 72 in total over the 10-year period, of which own nationality was 5. And Slovenia surrendered to the UK 2, of which own nationality 0. And so, I do obviously appreciate the focus on the difference, but we believe that in practice this will be, as I've indicated from those numbers, quite small.
To your point, and it's useful to have those numbers. And is it Germany, Austria, and Slovenia that we're talking about? Are there any other countries that might be in a similar situation?
They are the three that have indicated thus far. Obviously, it is open for other member states to make a declaration, but the point being is that it isn't that means that there is some absolute bar. We have, for example, negotiated an agreement with, for example, Albania that had a similar sort of bar to enable a bilateral agreement to enable that to take place. And so all I think I'm saying to you, Mr. MacDonald, is that we know that there are those three, of which there are a small number, but equally there are other arrangements that can be put in place to ensure that people are brought to justice if needs be in their home country. And it is precisely that type of approach that we would expect to see maintained.
And I mean, what sort of preparation has been done to try to take that approach, and what sort of other examples are we learning from? Because, you know, prosecuting a serious offence in Germany is obviously going to be a much more difficult task than doing it here. How does it work exactly?
Obviously, it's a question of the individual crime that may need to be prosecuted out, and I think it's the fact that in this country we have a very narrow approach to extraterritoriality, whereas other countries that have that approach are much more expansive in asserting extraterritoriality, which is why I sort of make the point in the way that I do about bringing people to justice in the home state. So it would be a question of liaison around evidence, and we obviously would expect support and contact to be provided to victims of that crime as well. And therefore it would be by way of bilateral support that we would offer in terms of exchanges of evidence and indeed in terms of the way in which this would be conducted. I would point to the fact that there are live cases that I'm aware of where, for example, it isn't possible to bring a prosecution in this country where a prosecution has been asserted, and therefore it is in the relevant home state, and therefore it is a question of ensuring that we just share the relevant evidence to be able to support that prosecution.
Okay, and when you are, so you've given us the figures for Germany, Austria and Slovenia in recent years, but I don't need the information just now, but it'd be useful to know the nature of the crimes that they were also been extradited for, because obviously, you know, the numbers may be small, but the significance and seriousness of those crimes is also of interest to us. Can you also just comment on timescales then, either under a sort of Norway-style agreement or under the 1957 convention? I think, as I understand it, correct me if I'm wrong, under the European arrest warrant, you've got sort of strict deadlines of 10 and 60 days. Under the convention, you could be talking about a process which takes several months instead.
No, there are, you know, I think it is right to say that there are different processes that would operate, and clearly a surrender agreement, we believe, still can be fast-track, and therefore not seeing a great differential between performance from the European arrest warrant compared to fast-track extradition arrangements as would be similar to Norway and Iceland. Obviously, in moving back to the arrangements under the convention, then you know, again, it's tried and tested. We know the processes that are there. I think it obviously will depend on each individual member state as to the nature of their preparedness. So it's difficult to be able to say specifically what a timescale would be. Obviously, there are slightly different processes that would operate that could impact on timing, albeit that European arrest warrants, even with the sorts of measures that you outline, equally still do take time, and rightly so, that there are processes before the court that would be equivalent and similar. So whilst, yes, there are differences in terms of timing, I think it is difficult to make some of those direct judgments in the way that that I understand that you would wish to make.
Other witnesses, in fairness, managed to make them, like the NCA last week and so on. So I'm not just making up months.
No. I would never suggest otherwise, Mr. MacDonald, that you would be.
In terms of legislation, you obviously referred earlier to the Extradition Act. Is there anything else that would need to change depending on whether or not there's agreement? Any legislation that would be required between now and the end of the year, or would it be done by statutory instrument if there are powers to do that, or what is the plan?
If there is no further agreement, then no further steps would be required. And so just to be clear that is the case, and we are ready from a legislation and indeed an operational perspective, and the support that has gone into the ICCC, effectively the Police Coordination Centre, where we have the National Extradition Unit, which is established to support that. So we are ready for that, as well as with CPS and with the UK Central Authority. Obviously, we wait to see what may or may not emerge in terms of the current negotiations. It is possible that further legislation may be required, depending on the nature of agreements, as I've already indicated to the committee, and we stand ready to be able to move quickly, should that be the case.
Final question then, sensible minister, you've got your head screwed on. Surely, to goodness, you are knocking on the door of number 10 and saying to him that things would operate much more smoothly if we extended the transition period, even for a short period. That, in the circumstances, given everything that's going on, even today, is the sensible option, is it not?
I understand why, Mr. MacDonald, you might wish to make that point, but the clear position of the government, and indeed as enshrined in primary legislation, is that there will be no extension to the transition period.
I'll put that down to collective responsibility. Thank you very much.
Diane Abbott.
Thank you very much, Chair. First I'd like to thank our witnesses for taking the time to give evidence to this committee on what must be a day which is a little bit busy for them. I've listened to the responses the Minister has given my colleagues, and the Minister has made a lot of how when we Brexit, after we've Brexited, there's going to be a close collaborative arrangement with other EU law enforcement agencies. But the truth is that it can be as close and collaborative as you like, but there are databases that legally we will not have access to. Can I start by asking the Minister about the European Criminal Record Information System? Is it true to say that we will lose access to that on the 1st of January?
Well, as I've indicated to the committee, if we are in no further agreement, then obviously we would then move to the 1959 Convention of European Convention on Mutual Legal Assistance that would support the exchange. What that means is that we would make requests through ACRO, which operates this on behalf of policing. And they've implemented a new IT system allowing for the transmission to take place via secure email, which will allow for an electronic exchange without the use of ECRIS. And the timescales are dependent on the response times and capabilities of EU member states. Obviously, should an agreement be reached, as we have set out in our published approach to the negotiations, our ambition is for an agreement which would provide for the fast and effective exchange of criminal records data between the UK and individual EU member states. And this obviously is a capability that is important for both of us in terms of being able to have those exchanges. But as I've indicated, we have put in place alternative arrangements should that be necessary.
Currently, we use the European Criminal Record Information System 4,000 times a week. Are you saying that your alternative arrangements can be as speedy as that?
Well, I think, and I appreciate this, that as was made clear to, I think, the committee last week, ACRO's estimates on perhaps sort of the average non-EU requests obviously vary according to country. And we're confident that under the Council of Europe Convention that this would be unlikely to take as long with EU member states. Obviously,
I wasn't talking about the length of time. I was talking about the number of times we use 4,000 times a week.
Well, if I look at the numbers, and the numbers last year, we sent over the entirety of the year 100,000 requests for information. We received 30,000 requests, and also we sent notifications to the EU of around 30,000 and received 10,000 back. It's why I do sort of make the point about the ability to have a sort of a new IT system to allow transmission to take place via secure email, why we have put that in place, and how we are committed to working with member states whose technical abilities may be more limited to improve the basis for exchange in the future. But we do remain confident that there is an approach that would support the sharing of information in an effective way to protect the public, yes.
No one is saying that you won't have a system that will support the sharing of information. The question I think the public want to know, this is a system we use 4,000 times a week, 4,000. Is the system that you're talking about going to make it possible to have that volume of access?
Well, as I think I indicated, Ms. Abbott, the system that we have put in place to be able to make those requests under the Council of Europe Convention, do provide the basis for an exchange and do provide the basis to make various exchanges to provide and give assurance to the public in relation to safety and security. And so it is that flow of information in both directions that obviously underpins so much of the work that we do, and which would be continued through the arrangements that we are being put in place. So, of course, it is a different arrangement, and I will appreciate, and rightly and responsibly, that the committee is sort of seeking assurances as I think the public would expect us to do. I think what I can say to you, Ms. Abbott, is that we will have those arrangements in place to see that the exchange of criminal record data can continue to provide assurance to the public. Yes, it will be different, but nonetheless, that it will provide that basis to support law enforcement activity and to sort of ensure that they're able to operate well. But it's clearly a different system. But as I indicate, we will continue to work closely with member states, some of whom are not as have some individual technical support issues. We will continue to work with them to support them in terms of the mutual exchange of information in this front.
So you're unable to confirm whether your new system will actually mirror the 4,000 strikes a week that we're able to use with the European Criminal Record Information System?
I think
you're unable to confirm it. You say you've got a new system.
It's a different arrangement which allows for exchanges of and requests for information to be given. And as I've indicated, we have put in place a new system, a new IT system, to allow for the transmission to take place via secure email, allowing for an electronic exchange without the use of ECRIS. And I think that's the point that I'm seeking to make to the committee, that does support the exchange of information, recognising the importance that we both attach to this.
Well, the point I'm trying to make is it's fine you've got a new system, but will our law enforcement agencies be able to access it 4,000 times a week as they currently do? But let me move on to the Schengen.
I think it's just important to say that it's the making of requests. It's not a database as such. It's individual requests that we receive from member states, and obviously we then make to member states, and they then provide the information back to us. So it's that nature of the system that we are seeking to put alternative arrangements in place for.
Let's move on to the Schengen information. As matters stand, we will lose access to that when we Brexit on the 1st of January. I'm asking, I don't want to make any assumption.
Well, we have we've maintained an offer to the EU consistently on the ability to have data exchanges in an equivalent framework to SIS2. The Commission has stated its view that it is not legally possible for a non-Schengen third country to cooperate through SIS2, and that a future agreement between the UK and the EU need not provide similar capabilities. We regret that is the case, but that is the position that the EU have taken. Therefore, we will need to operate outside of the SIS2 structure, and how, therefore, we look to alternative arrangements, Interpol being the ability to share fast-time alerts to effectively operate in the way that we did prior to 2015.
That was my initial point, actually, that legally we wouldn't be able to access some of these databases, however closely we want to collaborate. Last year, we used the Schengen Information System 603 million times. Are you confident that whatever system you think you can organise can allow that volume of access?
It's important to explain on that, Ms. Abbott, that number effectively counts every PNC search, every search at the border, where there may have been almost like automatic access that's been taken. Therefore, if alerts have been provided, it is about the nature of identifying an alert. And so I think it's important just to understand what that number actually means, and that it's effectively every time a UK law enforcement officer checks border or policing systems. So those border and policing systems will be maintained. It is a question of the alerts being provided in a different format. So I hope that sort of explains. So in other words, if we're seeing a country wanting to put an alert on, or indeed us wanting to alert an EU country, putting that alert in through Interpol to see that then is able to flag that up against that search.
So you're saying that we will have the same volume of access under Interpol as we currently have under the Schengen Information System?
Well, the different systems, and I think it's important to state this. We participate in SIS2 in relation to the law enforcement element. We don't participate in relation to the immigration element. So when we look at some of the numbers that are on SIS2 already, we don't actually already have access to all of that information. So I think it's that point one is important for me to explain. Obviously, there are alerts that are put onto Interpol, and therefore it would be the Interpol system that we would be looking to facilitate the exchanges, for example, through red notices of those who should be arrested for extradition. And so it's using that mechanism rather than SIS2 to make those alerts, as I say, in the same way that we did prior to 2015. And when we look at, for example, relationships with Ireland, who are not currently part of SIS2, it's that sort of arrangement that we already operate with Ireland.
Can I move on to passenger name records, which apparently we access once a day? Are you confident that the alternative systems you would seek to set up will give us that volume of access?
Obviously, with passenger name records, the desired capability through a negotiated outcome is a legally binding international agreement on PNR between the UK and the EU, and transfers from EU airlines continuing in that way. In the event of a non-negotiated outcome, we will engage directly and are in contact with EU airlines directly, operating to the UK to seek to conclude arrangements for the transfer of PNR data to the UK in compliance with relevant data provisions. The proposed agreements will set out the data protection safeguards, although it is a decision for each airline whether or not to conclude a data transfer agreement with the UK, albeit that there are sanctions if airlines do not transfer such information.
And will these individual arrangements with the individual airlines be as speedy as accessing the passenger name records?
If an airline agrees, then it is using the same systems and processes to be able to do so. Obviously, it's also worth stressing that we have passenger name records, but we also have advanced passenger information on effectively the advanced manifest data that is provided, which would identify if there are named individuals that are wanted. Again, it would be flagged up through that measure. That would not be affected by this discussion. It's the PNR data, some of the additional information that we gain from PNR that is relevant.
And finally, the PRUM system of the exchange of biometric data. Since June 2019, we've had 13 13,000 matches, which obviously means there were many more hits in order to get 13,000 matches? And are you confident that any alternative system you might set up will have the scale and the utility of the PRUM system?
I think again, it's worth explaining what the PRUM system is. In essence, it is a way of washing the data that is held on one database as against the data that is held on the database of the relevant member states. Therefore, in joining PRUM, and obviously we have had those matches that you have identified, Ms. Abbott, the 13,000, and equally from the EU standpoint, they've had 43,000 matches on our own database because we have one of the largest in the EU. Actually, that gives you your sort of highest level of utility at the outset because it's a hit-no-hit basis. That is the only information that PRUM gives you, whether there is a hit on someone else's database. You then have to interrogate that on a bilateral basis to get more information. So the sort of the strongest position that you get is almost through the outset by flagging that there is that connection that you're then able to follow through. If we are in a non-negotiated situation, we would exchange DNA and fingerprints through Interpol and mutual legal assistance requests in line with the approach that we actually adopted on this prior to July last year. And obviously in terms of PRUM fingerprints in October of this year. So obviously there are already arrangements that we've used in relation to these exchanges until very, very recently.
Well, just finally, Minister, in the event of no deal, and you said earlier that it was a reasonable working assumption that an agreement wouldn't be reached. In the event of no deal on the 1st of January, we'll lose direct access to European Criminal Record Information System, which we currently use 4,000 times a week. We'll lose direct access to the Schengen Information System, which we currently use or currently access 603 million times a year. We'll lose access to passenger name records, which we use once a day, and we'll lose access to the PRU system for exchange of biometric data. Can you tell the committee with complete confidence that none of this will have any effect on this country's crime fighting capacity?
Well, we've already just explained in relation to passenger name records, the alternative arrangements that we are having those discussions with individual airlines, and indeed in relation to the use of Interpol and Interpol red notices as contrasted to SIS2. We will continue to be a global leader on security, as I've already said, and one of the safest countries in the world. And the UK had a high level of security before these measures came on stream. As I say, SIS2 2015, ECRIS 2012, PRUM in 2019. And in any scenario, we will continue to be one of the safest countries in the world. Of course, there is difference here, and I've already explained that to the committee during this evidence session already. But I would underline, and that sense of confidence to the public of the importance that we do attach to the safety and security of our citizens, and indeed the way that the police and the National Crime Agency have underlined that they are prepared for any eventuality. This is incredibly important, and I would certainly want to stress to the committee the absolute weight that we give to safety and security, and how and why we have made all of the measures, all of the steps that we've taken into account over the last number of years in preparedness to see that we do remain one of the safest countries in the world.
Thank you very much, Minister.
Thank you. Just a couple of follow-on questions.
Of course.
Diane Abbott's points there. So how many airlines have you reached agreement with to get that additional passenger name records information?
This is a very live discussion, Chair, and obviously because of the nature of those discussions, I can't confirm today the specific nature because of the very live negotiations that are taking place. I can assure you that We are in contact with all relevant airlines, and if it would be helpful, I'm very happy to update the committee, given that this obviously is a very live discussion, and in terms of the airlines equally assessing whether no agreement or whether agreement is in place as to their own approach to this. But I'll be happy to update the committee with further information to give that sense of clarity.
There's only 10 days to go.
Well, as you will have heard, Chair, from the points that have been flagged by others in evidence to this committee, the steps that are being put in place have been rehearsed, and we have been through this before with airlines in terms of when no further agreement was contemplated previously. So this is a discussion that has been had previously with the airlines, and it is that nature of the arrangements that they will be coming forward with the confirmations. And as I've already highlighted, if they do not, the sanction that is there in terms of the non-provision of PNR data.
So if did any of them agree last time round, when you were doing the preparations last time round, did any of them actually come to an agreement with you to provide that information?
I don't want to sort of breach commercial discussions, but yes, some of them did, yes.
And have any of them, you don't need to tell us which ones up to this point, but have any of them reached agreement with you now to do so, to provide the same information?
We do have an agreement, and there are live discussions that are taking place.
And at what point do you need that agreement in place for it actually to be implementable in practice? Presumably, you know, quarter to midnight on the 31st of December is a little bit late in terms of having the practical systems in place.
No, actually, because effectively you're using exactly the same systems that we have already. So nothing would change. So that's why, and I appreciate why you would be looking at the timing here, but actually this can be agreed very quickly, and then it would maintain the arrangements that already operate, which is why the discussions as took place last time were late, and indeed in terms of why discussions are taking place with airlines at this point in time rather than previously.
And would that give you every bit of information that you currently get through the PNR agreement?
If an airline agrees, then they would provide exactly the same data, and it is why I make this point about the sanction potentially being there if they were not. So we have clarity as the information that would be provided, and indeed the systems to be able to do that.
And those, let's suppose some of those airlines are based in other EU countries. Is there agreement from the EU that they have the legal basis to be able to provide you with that information? Suppose they want to, and they've come to an agreement. Is there a legal basis for them to be allowed to do so?
Yes, it's standard terms, effectively standard terms and conditions, and therefore the sort of data protection arrangements that can exist and indeed have been tested previously. Those terms and conditions have been updated in the light of recent EU case law, and therefore that is something that is understood in terms of, for example, our GDPR and the protections that we afford in that regard.
And then on ECRIS, how many other European countries don't have the technology in place to be able to respond to your requests swiftly?
I think it's the fact that we have a system to take place via secure email. I think the point that I was making is that that system is there. It's that some EU member states, for example, don't have the police national computer type of system. So in other words, EU member states, as they do now in terms of their support of ECRIS, would go back to potentially some of their own more manual systems to be able to obtain the data. So it's more the sort of pre-existing arrangements that already sit within EU member states and the manner in which they hold and record their criminal record data. So it's more how we would continue to support them, should that be welcomed or appropriate in terms of their ability to provide the timeliness of information in terms of the systems that are put in place.
Are you relying on them providing additional staff to reply to your emails?
No, it's the fact that I'm conscious that I've not brought in one of my my officials, Chris Jones, in relation to this, who may equally want to add to what I've said. But I think it is rather that that information is shared through ECRIS. It is rather that how information requests are made using our email system that I've already pointed to, and therefore, yes, they will be receiving those requests under the existing convention that we would be relying upon in terms of our legal basis for those requests, and therefore it is that type of responsiveness that that they would need to provide to those requests, and hence the reason why we look to support in whatever way we can.
That sounds like they do need additional staff in order to be able to respond to your requests. If the current system takes 6 days, if you are resisting the assessment that it's going to take 66 days on average in future, what is your current estimate of how long on average the new system's going to take?
I think it's very difficult for me to give, and that's not the. It's difficult to give an assessment until we have been operationalising this. The date of 66 obviously is an average of all of our sort of international contact. That's likely to be skewed by a number of countries that may take a very, very long time. I think all I can say to the committee is that we expect it to be in a much shorter period than that.
But longer than 6 days?
Sorry?
But longer than 6 days?
Not necessarily, no. And that's what I'm saying about it being about sort of individual member states and their responsiveness around this, and how we obviously will be using these new mechanisms and the responsiveness that they give to that. But I think I suppose what I'm trying to challenge is the sort of data of the 66, which is a much wider average than that takes into account all of the world, and therefore our expectation, given the systems that are in place by EU member states, that it will be a lot shorter than that.
Indeed, but just trying to probe you on this, though, are you seriously saying to us that you've got this new system that you'll have to operate from the 1st of January, that no other European country has operated before, that they'll only be doing for us because of a lack of agreement, and that it may well not take longer than the current 6 days? Are you seriously telling us that?
I can't guarantee that. Of course I can't, and I appreciate why you sort of frame it in that way, Ms. Cooper. But of course I can't guarantee that, and that will require the responsiveness of EU member states. The simple point I'm saying is that the 66-day average is weighted from a wider international perspective, with a range of different countries that will not have the same sorts of systems and processes that EU member states will have put in place as a consequence of ECRIS. I think that's the simple point that I'm trying to make here.
And have you practiced this new system?
Well, obviously, we currently operate ECRIS. It is an email system, so it's a secure email system to the relevant individual member states. And so
but have you practiced it with any of those?
We're confident in the system, but it's obviously how EU member states respond to that. And that is obviously what will need to be seen in the new year. My point is one about the average in terms of performance.
Fine, but so it sounds like that hasn't been practiced on. And on the SIS2 and Interpol relationship, is it right that you will have to delete 40,000 individuals from your databases on the night of the 31st of December?
Yes, I think you point to the 38,000 person alerts on SIS2, and in particular the specific part on what falls under, I think it's Article 26, which relates to the alerts on things like European arrest warrant. We would need to delete those. You are absolutely right, in the same way that EU member states would need to delete the equivalent information relating to the UK, albeit that the analysis that we have seen in terms of the increased number of red notices, we have already received approximately the same amount of Interpol red notices from EU member states. So, obviously we have that deletion that takes place, and equally then the keying that individual member states would need to do to see that data becomes available through Interpol rather than through SIS2. But certainly the assessment that I've seen on those wanted for arrest and extradition, that we have already received approximately, I can't say it's exactly the same number, but approximately a similar sort of number in terms of increases in Interpol red notices.
And so your assessment country by country, have all of the member states fully uploaded their current live arrests or suspects, people that are wanted for arrest or suspected of crimes in their country? Have they fully uploaded those onto Interpol, the cases that they currently have on SIS2?
I cannot guarantee every single case, because obviously that is a matter for each EU member state. What I can say is that when we look at the number of SIS2 alerts related to those wanted for arrest and extradition, we have seen an equivalent number of Interpol red notices that have been put on by EU member states. It's difficult, as I hope the committee will understand, it's very difficult to do that sort of case-by-case analysis over that sort of number. But what I can indicate is that we have seen EU member states, I think, responding to some of the issues that understandably we would be concerned about.
But my question is that for all member states? So is your assessment, have you done this assessment on a member state country by country basis to see whether there are any countries that are not doing this, and whether there are some countries that are way ahead but others that aren't?
I think it's difficult. I think that the evidence that you received last week, I think, rightly highlighted that Interpol does not publish, and our systems are not currently configured to provide a breakdown of alerts by country, and figures relating to use of Interpol tools by specific countries are not made publicly available by Interpol. What I can say is that we have had extensive engagement with EU member states and are confident that critical alert information will continue to be shared with the UK. And as I've said, the overall numbers that we have seen would certainly give that indication of seeing approximately the same amount of Interpol red notices from EU member states. But systems in terms of individual member states are not calibrated on that basis, and indeed Interpol itself does not provide that breakdown.
And what about vehicle alerts or license number plates and so on? So currently there'll be a huge number from France, for example, on the SIS2 database at the moment. Where will you find that information in future?
Again, we through Interpol will be able to access approximately 90 million records on suspect documents. So there are means through different forms of Interpol notices to provide alerts, and so it is again through that mechanism that we're able to information is able to be shared on documentation, and it is that type of volume that we are able to access. In terms of the visibility, again, because Interpol does not provide that breakdown of the manner in which EU member states use or provide notices in that way. Unfortunately, I can't sort of provide the committee with further detail in that regard, but it is through the various different strands of Interpol that EU member states will be able to share documentation and other forms of information.
But at the moment, there are about 68 million issued document alerts, potentially false documents and so on Europol. There's a further 3.5 million vehicles listed on Europol. on just vehicles and issued documents, if Interpol's only got 90 million and the EU it already accounts for around 70 million, that doesn't sound like you've got equivalence on issued documents.
I think it's also, and again, this is important to stress, is that the vast majority of documentation, indeed, if we look at the person alerts on SIS2, that relates to immigration purposes. We do not participate.
Well, I'm not asking about those. I'm specifically not asking about.
If we just, I'm sort of talking about, if I was sort of highlighting some of the macro numbers, but it is a question of obviously information that is provided for those different purposes within SIS2, and therefore the ability for countries to share data in different ways, as I've indicated, using Interpol.
Sure. So you don't have detailed assessment of other EU countries and which of them are fully putting, for example, their suspect vehicles onto Interpol compared to on Europol?
No, that would be a question for each individual member state. But
so as a result, you can't assess.
That information isn't provided by Interpol and isn't readily provided by EU member states. What I can say to the committee is, as I've sought to do, is I think the way in which individual member states have recognised the issue here, and indeed as far as the closest, and let's not forget, there's not complete alignment between what you can put on SIS2 and what you can put on Interpol. There are different recording sets, which is why it's not completely like for like. But what we can say is, from the discussions that we've had with member states, that these issues are recognised, and as we've seen from the red notice provision, an increase in the number of red notices that are coming on from EU member states.
But you can't assess the scale of the capability gap then, in terms of the differences between the Interpol system and the Europol system.
It's the
Interpol system and the SIS2 system.
I understand. Genuinely understand why you press on this, but they are different systems, and so the way in which they record data, the way in which they operate, is different. And so, as I say, because of the immigration nature of SIS2, and equally the more crime-related approach to Interpol, and so they are different systems that are calibrated with different data sets in different ways, which is why they're not a like-for-like equivalent, and why we have underlined that sense of the changes that do take place. But equally underlining the emphasis that is being given to public safety, and seeing that police remain able to arrest and to be able to share data through those means, as well as bilaterally, which equally remains an incredibly important part of the way in which law enforcement operates.
Sure, but then just in conclusion then, so you're saying, of course, the police are going to continue to be able to arrest people, but would you accept that if there's much less information and it takes longer to get it, they'll be arresting fewer of those people?
No, again, because of the focus on, for example, the Interpol red notices and the utility, the very low, the overall very low fraction of a percent, for example, that may be a hit when you look at all of the aggregation of the data. I don't think you can make that direct read across. Obviously, there are different systems that have been put in place. As I've indicated, the mutual change in capability between the UK and the EU member states. But does that sort of prevent police officers from making arrests? No, it just does it in a different format. And so it is, I suppose, that emphasis that I would give. It is clearly, we want to ensure that in whatever arrangement, that we continue to collaborate closely with EU member states and the very, very good law enforcement cooperation that already takes place. And this very close communication that law enforcement does operate. So I think that is what I would stress, albeit that, yes, there are changes in arrangements here, and I would not want to pretend otherwise.
And do you accept that there is a very different tone in your response to this than to all of the senior police officers who have given evidence to us, who are clearly considerably more alarmed than you are about the loss of capability that they're about to face, about the major operational impact that they describe as a result of losing access to these tools if there is no agreement in place on the 1st of January?
Well, I think I would underline the public safety message that all operational partners have given, and that they are prepared for all outcomes and all eventualities. Obviously, there is a change in arrangement. There is a mutual loss in capability, which I've already said to the committee. But does that fundamentally alter the UK being a safe place for its citizens? No, I would contend that it does not, albeit that, yes, there are different arrangements, different systems that will operate in different ways. And why, even at this stage, we remain optimistic as to what can emerge, but that does require a shift in the overall negotiations. Nothing is agreed until everything is agreed, and we know very clearly that there is a gap that still needs to be bridged. We will see what happens in the coming days, but I do want to underline to the committee the preparation, the incredible work that so many in law enforcement and through our operational partners have done. I absolutely pay tribute to them, and we remain and will continue to listen incredibly closely to what they say and to support them in their work.
Have you put forward proposals for a fallback security agreement if no agreement is reached between now and the 31st of January on fish or level playing field or the other outstanding trade-related issues?
I think what I can say to the committee is that, as the Prime Minister set out in October, we do remain willing to discuss the areas where a lot of progress has already been made, including on issues such as law enforcement and security. Clearly, we rightly prepare for no further agreement being put in place. And that obviously is where we have spent a lot of time in this session, rightly underlining all of those measures and the steps that will be put in place. But as the Prime Minister said, if there is no further agreement, we do remain willing to discuss areas where there is that mutual sense of cooperation, and where there is, I think, that congruency, that sort of shared outcome that I think that, and a shared understanding which we have on these issues.
And we would hope that there will be a security agreement, even if other things can't reach agreement. We would certainly hope that there could be a security agreement. If that security agreement is not in place, I've heard everything that you have said about continuing to be a safe country, but will we be less safe if we don't have a negotiated agreement on security in place?
I think it would be wrong to suggest that this country somehow will be less safe. The arrangements are different, and as I've already indicated to the committee. But does that mean that we will not be a safe country? No, I don't. That's
not the question I'm asking. I'm not asking on your assessment about whether we are safe compared to other countries in the world. I'm asking whether, as a result of not having a negotiated agreement in place, we will be less safe in January than we are in December.
As I've indicated, Ms. Cooper, I think that we will remain safe for the reasons that I've highlighted.
Not the question I asked.
Well, but the point is that, and I go back to what I said about the fact that on SIS2, on ECRIS and on PRUM, that we have only recently joined those. And therefore, how we were one of the safest countries in the world then, and we will remain one of the safest countries in the world now. Yes, there are changes in capability that we are seeing, as I've indicated. But does that mean that we can't continue to fight crime, to collaborate with our international partners, to see that using the Counter-Terrorism group of European partners that we combat terrorism? Absolutely not. And therefore, I believe that we have put in place contingency arrangements that will assure the safety and security of our citizens. And
Minister,
that remains our priority.
You are not answering the question I asked. You are answering a different question. I am not asking you whether or not overall you're safe. You have what your overall assessment is of the safety of our country. I am asking you whether in January we will be less safe than we are here now in December. Not how it compares to a couple of years ago when we didn't have some of these tools, but compared to right now. If we don't have these new security agreement in place, will we be less safe in January than we are now?
And as I've said to the committee, I do not see it in those terms, and I believe that we will remain a safe and secure country, and with a non-negotiation, or indeed with a security agreement, I believe that we will remain as safe because of the incredible work of our policing and indeed the different steps that we have put in place. So that I think. I hope responds positively to the question that you've asked in terms of safety and security, and that we will remain a safe country, and that we are putting in place the right measures to assure that. And of course, there are differences, there are changes in capability, but I believe that with the steps that we have put in place, with the incredible work of our police, that we will remain as safe as a consequence of those steps that we are implementing.
I have to say to you, Minister, I think that was a remarkable thing for you to say then, and to say that you now think that we will be as safe if we have no negotiated security agreement in place as we are now. I think that, look, I understand your unease about answering my question, and you avoided answering the question many times. But when you finally answered it, I'm actually more astonished by your answer to the question, especially in the light of everything that the police have told us. And I think it's also probably not the right thing for you to do in terms of your credibility with the police that you need to work with, who you rightly said are working so immensely hard.
Absolutely.
Let me put to you finally then the words of Neil Basu, the counter-terror chief, who said the UK will be less safe without the EU security deal. He said that's the bottom line. So is he completely wrong?
I obviously respect Neil, and we talk very, very regularly in relation to counter-terrorism issues. I think what I would say is that there are a range of measures, and we will see what the position is at the end of this year, and the negotiations that are very, very live. But with the different measures that we are implementing, indeed, the arrangements on counter-terrorism through the Counter-Terrorism group, that I believe that this country can and will remain safe. And I, of course, I understand the desire to point in different directions and to rightly highlight the difference in capabilities that and the changes that we'll be putting in place. But I remain positive as to the arrangements that we are stepping up. Of course, we want to see an agreement, and that I would not want to give the committee a sense that that we are turning our backs or our face against that. But ultimately, that does require an overall agreement being put in place in terms of all aspects. But those negotiations continue. We remain positive that a shift in the EU's position can happen, but nonetheless that we remain focused on delivering on all of the other aspects that we have touched upon in this committee to see that this country remains safe and secure, and how that absolutely is the priority of this government.
Well, you have 10 days to go. I think it is deeply unfortunate for all of those police officers, but also all the border force staff and actually all the victims of crime as well, that they've been put in a position by both the UK and the EU negotiators that we don't have an agreement in place, and none of them currently know what systems it is they are going to be implementing from the 1st of January. We would certainly pass on our huge thanks to all of the police officers, border force staff and Home Office staff who are going to have to be working immensely hard during the Christmas period, who've probably had their remaining Christmas cancelled as a result of these delays in getting any kind of agreement or any resolution as to what will be in place. So please do thank all of them for us, and we
thank you, Chair, and I will certainly pass on that message, because I think there is a shared appreciation from all of us of the incredible work which is going in at this really challenging time. No, I will certainly echo your really powerful and positive message from this committee as to the support we all give to them.
That would certainly be welcome, because I think we do hugely thank them for their work after what's been a very difficult year. But I would just I think just as a final comment to you, Minister, you have, in the evidence that you have given us today, you've said we don't have, if we don't have an agreement, we'll have to use the 1957 convention to arrest people, which we know will take longer. It will take longer to get criminal records, though you don't currently know how long, because you're going to have to rely on a new email system that hasn't been operated before. You've got no agreements yet in place with airlines as to the passenger name records, although we're fingers crossed, we hope that will be in place in time. You're not going to have a replacement in terms of the DNA system. We're going to go back to the old one, despite the benefits it's brought. And with SIS2, it's going to be replaced by an Interpol system that we know is going to be more bureaucratic, and we don't have the same Europol support in place. Listening to it, it certainly sounds as if Neil Basu knows what he's talking about when he gives such stern warnings about the importance of getting a security agreement in place. So to the extent you are able to have any influence on these processes, I strongly hope that you will, and I strongly hope that we will get a security agreement in place. But can I also urge you to level, not just with the committee, but also with the public, about what the consequences will be if we don't, because being honest about some of the consequences, and maybe serious consequences, will be extremely important as we go forward. Can I thank you very much, Minister, for your time today, and also to your officials as well, and wish you well with the ongoing negotiations, discussions and preparations over the next 10 days. Thank you very much.
Chair, and can I wish you and the rest of the committee a happy Christmas under obviously the different circumstances that we will all be marking that with. But thank you, and no doubt we'll continue this discussion and continuation in the new year.
Thank you very much. Thank you.
Thank you, Chair.
Order.